been part of it. Okay. What else is? Jury. No, we're good. I just got out here. We're getting stuff set up. All right, good morning, everyone. We have 3 matters today. Ms. Rios, are you handling Leslie Cook?
Yes.
So you're handling all 3?
Yes, there might be a 4th add-on.
A bonus.
Yeah, she's, if she shows up, we have a plea worked out on the person that we changed the bond condition so she'd go to her daughter's graduation.
Yes.
So we have a misdemeanor plea. So I'm just trying to make sure she's coming, but she should be here.
Fantastic. So Cook is a revocation. Jones is whatever.
The plea.
Oh, okay.
Go back into, he should be here. I'm gonna go back.
Got it. And then Daniel Jackson, what are we doing?
Plea.
A plea. Liking how today's sounding. Okay. I know why Ms. Dilligard is here, because for another 45 minutes, she's the line ADA in here. Ms. Charles, it's always good to see you. Is one of these cases yours?
Yes, sir, Mr. Jackson.
Oh, all right. Deputy Scott, are you going to need another deputy before we can start, or there's someone hiding back there? Great. Okay. Before we dive into these things, and we can handle them in whatever order, it sounds like, Ms. Rios, you may need to talk to some people first. Do we have a staffing update from the district attorney's office, or it remains we don't know?
Still kind of in limbo. I think they're trying to get the person that I thought is going to replace me approved by the DA still, and so it's still kind of not solidified just yet. But I do know that I'll be taking Ms. Charles' spot in DD, so I'll be able to keep her.
Well, I'm torn. I am excited that Ms. Dilligard, who is abandoning us, it's only a 80% abandonment, but where are you going to be? Oh, you're moving to another unit. Got it. And you can't do major case here. That spot's taken. Well, good for you. Do you know which?
Step in from time to time.
Do you know which courtrooms you'll cover?
I have a tentative, Judge McAfee and potentially Judge Inger, and a question mark by Judge Carson.
All right. Great. Well, congrats to both of you. I assume those are, certainly it's a promotion for Ms. Dilligard. Is it still viewed if you move into major case, that's the apex? I mean, other than the corner office?
Mm-hmm.
Okay. Well, good for you. And we know the DV cases will be going into good hands. Because you, Ms. Dilligard, will be staying here, it sounds like, are you going to consider and speak with your replacement about holding on to a few things that you're close to sorting out if they're complicated, or that's not allowed, or how would you go about that?
So I asked the deputy over in domestic violence the same question.
Who's that?
Ms. Besa.
Okay.
Besa. And she said if there was something that was close, then we can have a conversation.
Okay.
But there are a few on the top of my head, and there are some things that I'm gonna push to get done before I leave.
Yep.
But
We're calling it before you transition rather than leave. Yeah. Okay.
But either way, I'll be very excited.
Okay. I guess that's true. I mean, you would be insofar as what I want to avoid, if there are messy ones in which you've invested a great deal, is the defense attorney saying, well, wait, that's not what we had sorted out. And I fortunately have public defenders who aren't going to twist that, but I have had defense attorneys who would say, well, Ms. Dilligard promised a misdemeanor. And the poor new ADA is like, well, I just, there's no way this is a misdemeanor case. And that's in fact not what you promised, but no one can find you because you're doing other important things. So as long as you're staying plugged in a way where whoever replaces you is able to turn to you to say, like, wait a minute, I can't, your notes, I can't read these. What is it that you offer?
Yes.
Okay, good. All right. Ms. Rios, someone arrived and looked very anxious to talk with you.
That is Ms. Pitts. That's the one we have the plea that we're going to be doing the misdemeanor plea. Just have to talk for 1 minute.
The one who went to her daughter's graduation. How did the graduation go? From where did she graduate? What? Oh, Douglas High School. Excellent. I'm glad you were able to make that. I had a graduation this weekend as well, and it would have been not good to have to miss that. So glad you were able to do that. Assuming it went smoothly, you and your daughter didn't get into it. Okay, good. Okay. So Ms. Rios, should I come back when Deputy Scott tells me you're ready to go with stuff?
Yeah, only one that I don't really have to do a lot if we want to get Leslie Cook out the way, because that's not really a revocation from my what I'm understanding. That's the only one I need to talk. Well, according to Ms. Simpson, not really a revocation.
Well, how about I chat with Ms. Simpson while you're talking with other people? If doing Leslie Cook released someone else in the mix, I'd say let's knock that out. But Dilligard and Charles are stuck until you're ready on different ones. So why don't you talk with folks? I'll get educated by Ms. Simpson about the Leslie Cook situation, and then I'll just go back and do work and come out when Deputy Scott comes to get me. All right. Yeah, I see. Is she on for Cook?
Yes.
Okay, so talk to me about Cook.
So, he had to be originally with one of us and one was Gwinnett.
Oh, with Gwinnett, okay.
So, he was originally being a supervisor. And then I guess because he had his place here, case ended up with Officer Brown, just not to be sure. When he got out of custody from our.
Is this a case where he's homeless and there is, whether it's pad or something, but I need to lift the condition? Okay, got it. I remember. Someone very helpfully sent it probably was Officer Brown, sent something saying, look, we are seeking to modify probation so he can be back in Fulton so that she, Officer Brown. Yeah. Okay. And we don't want that to be a violation. I mean, it is a violation, but we don't want him getting locked up because he's getting.
He was just out.
Yep. Okay. And he's in custody because of that, or? Okay. Okay, we'll clear that up.
Oh, and Ms. Rios said that she was able to get into and things like that. He could on Friday.
Mr. Cook could?
Yes.
Okay. I can't remember, did you and I talk about probation and accountability courts since I met with Chief Lane? Anyone in the accountability courts will be treated as being in admin status from DCS's perspective, which means hands off. We don't do anything, meaning you guys don't do anything unless one of the accountability court judges says, oh, I need you to do X or Y. And then the auto on switch will be when someone's being terminated. And so if Fred Jones is there, you're terminated, and Mr. Jones was in accountability court as a condition of probation, then I would turn to you to say, please do a warrant because he just got terminated. And then that'll be what keeps him in custody until we have that initial revocation. And then, of course, the case bounces back to whatever judge sent the case to accountability court. But from admission orientation into any one of the accountability courts until termination, they'll be on admin status, which is, it was explained to me, no DCS officers doing a house check or anything like that. They will be in the background, and DCS will be and could be called upon to assist, but it'll be back the way it used to be, where accountability court investigators are the ones going to the houses to make sure it's a safe house, they're staying where they're staying.
Okay, so and I'll get clarification for that means, and for those who struggle, I will need to get reporting. I
think that's correct. I don't know about, I would hope that they have to initially report. I mean, historically, the way it was Mr. Jones.
Just need to do intake.
Right.
So that they can be in the system.
Yes, they got to be in the system, and then they're on admin status.
They're officially under.
Well, they would always have been under accountability court, but they're in admin status with DCS, which means there's no supervision. No officer is assigned to it. You would effectively be the officer because you're following it. If it's someone in my drug court, it would be your counterpart with Judge Krause who's following it, but you're not having to check every few months. Hey, is this guy staying clean? Not at all. You're just, because you would be the person showing up for drug court. If all of a sudden we were terminating Fred Jones because of something that happened, then when I say you're terminated, I know to turn to you, or you would say, I assume you want a warrant. I'd say, yes, please. And the basis for the warrant is terminated from drug court. Now, it may also be terminated from drug court because you picked up new charges. And so you and DCS can decide, do we say terminated and the new charges? I mean, it can be whatever.
So then let's say, do we still need to do, if it was like a severe violation, maybe Mr. Cook, meaning he didn't pick up any new charges, our drug court didn't work. We're gonna send you back to your
Right.
residential county.
And that would be up to the discretion of the judge. And so in Mr. Pilgrim's case, were you to ask, or if I were to remember, I'd say, we're not doing a warrant for him. I don't want him taken into custody. Right, you didn't, because there may be consequences, but it's more of an administrative termination. And so basically, if I'm letting people go out the back door, then DCS ought not to be taking out a warrant. But then we need to figure out, well, is that person, if they're going to stay in admin status, they could go be robbing banks all day long, and DCS doesn't have a mechanism to pull them back. So I would hope that for people who are administratively terminated, the result rather than a warrant would be, and now turn it to active supervision. So now Pilgrim does need to be reporting, and the person looking over his shoulder isn't Investigator Coggins from Hope Hall, but it's CSO Brown, who was assigned to him, or however that would work. Most of the terminations, though, as you've seen, are you're going through that door, and then we definitely want a warrant because that's all that would hold them. But it was a real good conversation with Chief Lane, and I think we're all aligned. And he already talked to XO to say, here's how it needs to work. So intake should still happen.
For those who are being broken, all I would need to do is just send them down to 276 for intake.
Yep. Intake, and then they're on admin status, and their clock is running. It's not like probation is told, but that's the whole point, is that they're getting good credit for it, assuming they're in accountability court.
Awesome.
Yep. And we told Chief Lane, let's try this, and if it creates heartburn on the DCS side, doing it that way, let's talk again in 3 months, and if we need to change it, let's change it. It just sounds like maybe because there had been a shift in management, there were people who were concerned, hey, McBurney is on probation and no one is checking on him. And so DCS has some exposure here. When of course people are checking on him, but it's accountability court that's doing it. And they were bumping into each other in ways that I've talked to you about, where it was interfering with some of the treatment approaches we were taking. And warrants were showing up. Judge Krause in particular would get warrants like, I don't want to sign a warrant. This guy's in drug court right now. So I think we ironed that out.
So I'm like, wait, what? I called them. Yeah, right. Thank you. And then I was like, I'm just like a little spot. And go, oh my God, oh my God, let me jump off. So I'm never good company. Come. I heard you. She's the final boss of people trying to check. I can't. Great. I mean, I'm not saying to say. Yeah. I was like. So we said, you asked for three, yeah. As what do we do in this budget when they take it out? It's pretty much. Is it more exaggerated? Because they charge 17. Oh, it's not coming down. Yeah. But the vendor could go. I haven't talked to him yet because I wanted to tell him. See. Cause I don't know. Do you have the warrant for the police report? Can you send that to me real quick? You did? So it's, okay. Organization. 100 hours, please. Okay.
Ms. Rios, are we good, or you're doing shuttle diplomacy right now?
We're good. I just needed to get some details for the second person. I have one ready, but I was forgot to ask you all.
Okay.
You're like, you know what, I should know better. Yeah. That's like, just like. Right. Wow. Got like. Even a flavor. Like candles, several candles. Yeah. Cases. Say what? We have to go with this. Ah, okay, sure. Okay. Okay. It's Friday. Oh my God. I caught it. Guilty. We don't talk. So like, and that's just like, that's kind of yeah. So I should chill because it was sometimes. It's just. Mhm. But I mean, you know. Yeah.
Ms. Simpson, do you have a copy of the warrant for, oh, Mr. Cook is really not a warrant. Is there a warrant? How's he must be if he's in custody.
He's friendly. Yeah, and they're back. It's okay. Yeah, he's
I need whatever document is holding him in.
I could be overstating that.
Thank you.
Oh, Judge, is probation means Saturday.
Mr. Cooks? Maybe his Gwinnett probation? Okay, because I got 3 years, 6 months and, okay. Oh, 2 days from now. Okay. Well, that's good for him.
So he could say. So, you don't look at the kids on that kind of tactical. That's a good way of put it. As a professional way to put it. Tactical. Entry. Yeah. Okay. And then how long was this? He's my older. I don't know how to address that. It's kind of something he was in the house. No, he's older. Okay. Thank you. He's cool with something. Yeah, he doesn't like them. He did. Sure. Get right to the break. Right. And everything is fine, is the interest, it's a little bit hairy. What happened? Everything. Two gym cows and that. And Gail was early. Megan was producing. They I'm sure that those are 2 years and you can push these things. So they could get all those skis for the kids. Yeah. And they have this lots of terrifying. Yes. Okay, don't everyone back in. Now what are we doing on pits? Count 1. Count 1 is battery, family violence. And 3 is reckless. Yeah. And 24. What 24? Can we do, if no issues, suspend after 12? Okay.
And if she completes all.
So at fit and 40 hours of community service. I don't know. Is there any other condition?
Sure.
Is there any other condition? Just that.
So family violence course
And 40 hours.
is 40 hours community service. Okay.
All right, who are we going to start with?
Okay, so I can do everyone in the back, Miss Pitts, I just need to talk to because we just figured that out, but I'm ready on the two pleas and the revocation.
Okay. Well, why don't we do Ms. Charles's case first, and then we'll only be tying up one prosecutor. Ms. Dilligard can go last anyway, so. Let's bring out Mr. Jackson.
We're gonna do Jackson, Daniel Jackson.
Mr. Charles, let me know when you're ready.
I'm ready.
You're ready. Okay. Good morning, Mr. Jackson.
Good morning. How are you doing, Your Honor?
I'm all right. How are you doing?
I'm doing okay.
Good. Mr. Jackson, you are out here because Ms. Rios tells me you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Okay. In just a moment, Ms. Charles, who's seated to my left and is the prosecutor on your case, is going to swear you in. Once you're under oath, she'll ask you a bunch of questions. I'll ask a few as well. The questions are just designed to make sure we're making a record that you understand your rights as a criminal defendant. If at any time during our conversation you are confused by what someone's saying or it's not going the way you expected, will you let me know?
Yes, sir.
Okay. And we'll work on answering your questions that way. Ms. Charles, when you're ready.
Thank you. Mr. Jackson, please raise your right hand. Do you swear or affirm the testimony you will give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Give me all your answer. Please state your true, correct, and legal name.
Daniel Jackson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication you normally take you have not been given today?
No, ma'am.
How old are you, sir?
33.
What is the highest level of education you have completed?
I have my GED.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that in indictment 25 SC 0000706, you are charged with the following offenses? Counts 1, aggravated assault. Counts 2, battery against a female who is pregnant, misdemeanor. And counts 3, battery, family violence, also misdemeanor.
Yes, ma'am.
Do you understand you have the right to plead either guilty or not guilty to the charges?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you about the charges in the indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes, ma'am, I am.
Has your attorney advised you of the minimum and maximum sentence for every charge for which you're pleading guilty today?
Yes.
And for the record, as to count 1, aggravated assault, the minimum sentence would be 1 year and the maximum would be 20 years. As to counts 2, battery against a female who is pregnant, misdemeanor, the minimum would be 1 day and the maximum would be 12 months. And as to counts 3, family violence, battery, the minimum would also be 1 day and the maximum 12 months. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state and the defense will make a joint recommendation to the court, but the court does not have to accept this recommendation. The court can sentence you to the maximum on every charge in its discretion and run the sentences consecutively, which means one after the other.
Yes.
And Your Honor, the recommendation is as follows. As to counts 1, we ask that you sentence him to 5 years to serve 6 months, committed to time to serve with the balance on probation. They will, as to counts 2 and 3, 12 months probation to run, 12 months to serve 6, balance on probation to run concurrently with counts 1 under following special conditions. That while on probation, he will complete the Family Violence Intervention Program. He'll also successfully enroll and complete the Family First Program. He will have no further violent contact with the named victim in this case, Cam Yotta Galmore, who he's currently married to, KAMYOTTAGALMORE. He will submit to probation substance abuse evaluation, follow all recommended treatment, and he will seek and maintain lawful employment. Sir, do you understand this guilty plea may be permanently recorded in your criminal history?
Yes.
Do you understand this plea may also be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal court? Do you understand then that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes.
Sir, are you a United States citizen?
I hear you.
Are you a United States citizen?
Yes, ma'am, I am.
Do you understand there may be adverse or unfavorable consequences as a result of your plea of guilty today, just as it would have been upon conviction after a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand then by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
Do you understand also by pleading guilty, you're also waiving the following rights? By pleading guilty, you're giving up the right to trial by jury. You're giving up the right to remain silent and not incriminate yourself. You're giving up the right to confront witnesses against you. You're giving up the right to the assistance of counsel hired by you or to court-appointed counsel. You're giving up the right to the presumption of innocence. You're giving up the right to testify on your own behalf and present other evidence. You're giving up the right to subpoena witnesses and compel the production of evidence. You're giving up the right to have the charges against you proven beyond a reasonable doubt. And you're giving up the right to appeal if convicted of the charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Correct.
How then do you plead to charge 1 aggravated assault in indictment 25 SC 000706?
No guilty.
And how do you plead to count 2 battery against the female who is pregnant misdemeanor in the same indictment?
Guilty.
And how do you plead to count 3 battery family violence misdemeanor in the same indictment?
Guilty.
And is your guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand you may only have a limited right to appeal this plea of guilty?
Yes.
Do you understand you have 30 days from today to file a direct appeal of your plea of guilty?
Yes, ma'am.
And you have 4 years from today for the felony charge and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the constitutionality of your plea of guilty.
Yes, ma'am.
Your Honor, the state is aware as far as a criminal history of 1 prior conviction for Mr. Jackson out of Michigan for an armed robbery in 2010. And had this case proceeded to trial, the state would have expected to show that on December 22nd, 2024, officers responded to the Cortland at Buckhead Village Apartments, Cortland is spelled Cortland, located at 3707 Roswell Road, Atlanta, Georgia, 30342 here in Fulton County, in reference to a domestic dispute. On arrival, they met with the named victim, Camiota Galmore, who was then married to the defendant, and she explained that herself and her husband had started a verbal dispute which became physical. It started ultimately when Miss Galmore first accused Mr. Jackson of cheating. That escalated into a situation where he accused her of being promiscuous and flirtatious on her social media. Eventually, she tried to walk away from the back room and he followed. And during the course of the second confrontation, where she explained that he smacked her across the face, officers were able to notice a laceration and a mark near her lip area and the face of Ms. Galmore. Ms. Galmore explained that at that time herself and Mr. Jackson had been married for approximately 6 months, had just moved from Indiana to Georgia in October of 2024. And she said at the time the relationship was troubled. And since we're having difficulty sort of getting things going in Indiana and also in Georgia. At the time, Ms. Galmore found out that she was pregnant. And she is, I believe, stated she would be with us on Zoom. She didn't want to give a statement today, and she's due to give birth imminently. And she explained that during the physical assault, he had dragged her out of the back room. Officers did observe some drag marks to Ms. Galmore. She was checked out, and she had no lingering injury to herself or her child. In speaking to Ms. Galmore, she's explained to the state that although their relationship was troubled, she and Mr. Jackson have sort of attempted to co-parent. She said at this point, she's going through some hard times. He is the sole source of support that she has here in Georgia. He does help her financially to pay the rent when they were together. She understands that they need to take accountability for his actions, although she doesn't wish to have him go down and be incarcerated for any more time than what he's done so far. Understanding her current position, she's 33 weeks and 2 days pregnant. She does want him to be present at the birth. We believe that the resolution we've crafted takes into account the totality of the circumstances, and we ask that you accept it as presented.
There is, I think, Ms. Gilmore, it's listed as Ms. Jackson on the Zoom call. I think she's on, but you said, Ms. Charles, that Ms. Jackson wants to be present, which she is, but doesn't want to be heard at this point.
She did say if you already have questions for her, she'd be happy to answer any questions, but she did not want to give an impact statement at this time.
Got it. Okay, thank you. Ms. Jackson, I do have 2 questions for you, if you don't mind unmuting.
Yes, Your Honor, I'm here.
Thank you. One, congratulations on the pending arrival of a new child. What is your best understanding as to the due date?
Well, last week I was told that my date was July 5th, 2025, but because I am a high risk, the doctors did change in my fetal monitoring notes that I'm due in about four weeks.
Okay.
So
And then,
as of now, it will be like 2 weeks from now.
okay. Excuse me. Other question was, I'm trying to figure out the right conditions to put on Mr. Jackson's sentence. So it sounds like you do not want a no contact provision. You want to be able to have contact with him. Were you thinking that the 2 of you would live in the same household, or just that he could be present in your household so he can help take care of the child?
I would say both. My husband isn't a threat to me. I don't feel like I'm in danger of my life. It was just that one incident. And when he was released in February, we still chose not to live together, but he was still supporting me emotionally, financially, and mentally, because this is my first child. So it hasn't been any problems.
Okay. Now I'm going to have to ask you another question because of that answer. Mr. Jackson has an open case in state court that includes allegations of battery against a female who is pregnant. I'm assuming that's you, and family violence battery. And the date of the offense is about a month and a half before this one. So the case we're talking about right now was something that happened on December 22 of last year. Mr. Jackson's state court case that is alive and well in front of a different judge. Something supposedly happened between, I'm assuming it's you and Mr. Jackson, given, I can't open the charging document, but given what the charges are, I'm assuming it's you. That was about a month before. And so you just told me, hey, we haven't ever had any troubles other than this. Was there actually another dispute that you all had in early November?
It was verbal.
Verbal, okay.
Yeah, it was a verbal dispute.
Okay. All right. But bottom line, you are not worried about having Mr. Jackson physically present in your life. That's something with which you're comfortable.
Yes, sir. Yes, Your Honor.
Okay, thank you.
Thank you.
You're welcome. Good luck in a few weeks.
Thank you.
So we have York from pretrial. Can I get any criminal history information you have for Mr. Jackson, please?
Yes, sir. Good morning.
Good morning.
One other thing, other than what the district attorney mentioned, she mentioned the armed robbery. I had a second offense, was out of Michigan as well. It was a weapons, firearm possession by a felon. It was enhanced to felony, habitual offender, second offense notice. And that was a conviction.
And when was that?
I'm sorry, that was April 2017.
Okay, so 2 felony convictions out of Michigan, no other arrests? And how many arrests in Georgia?
Showing 3 in Georgia, but no felony convictions.
Got it. Okay, thank you, Mr. York.
Yes, sir.
Ms. Rios.
Yes, Your Honor. Mr. Jackson is 32 years old. He has one son, 7 years old, and as you heard, he has a baby on the way. He would be able to go work back at DSL Logistics. He wasn't working as a forklift operator before being in custody. He wants to go back and work there so he can continue to provide for his 7-year-old child and the mother of a child and his new arriving baby. I'm just asking you to accept the plea as negotiated.
Okay. Mr. Jackson, your 7-year-old son is where?
He's in Michigan at the moment.
In Michigan, with his mother?
Yes,
Okay, so you provide financial support.
yes.
And the DSL logistics job is where?
Ellenwood.
Ellenwood? The address that I have in the system is Savannah.
That's the one
So,
I changed when we were trying to find a way for him not to live with the mother of his
got
child.
it. That was what you found.
Yeah.
Got it. Okay. I'm remembering now, and I was not super enthusiastic about that. Okay. That's the Savannah connection. So when you get out, your plan would be to stay with Ms. Jackson?
Yes.
Okay. And where is that in relation to Ellenwood?
I believe it's like maybe 30 minutes away. I think that's in East Point.
Okay. How will you get from East Point to Ellenwood?
At this moment, it'll be public transportation.
Okay. How do you know the job at DSL Logistics is still there for you?
I talked to my supervisor previous to getting incarcerated on this case. He told me he told me I was a good worker and all this. He told me when you get out, just reach out to me. We always need work. We opened up 2 more locations, so just let me know what's going on, and
Okay.
we'll create some space for you.
All right. Do you have any questions about what we've been discussing?
No, sir.
All right. And you and Ms. Jackson have been married for how long?
It's coming up on a year next month.
Okay. Ms. Charles, I'm not familiar with the Family First program. Was that a Ms. Rios idea or your
No,
idea?
Your Honor, it's a new program that is part of the Digital Training Diversion Initiative. And what it does is at low cost to the parties, it provides therapy as a family, especially when there's children involved, to help hopefully help them for long-term coping skills, conflict resolution. It's just an addition to the FIP, and it's something that we would want him to do as well as part of his probation, so we can hopefully leave them in a better place
Okay.
going forward.
All right. Well, Mr. Jackson, I find there's a factual basis for your plea. You put your hands on Ms. Jackson in a way that you shouldn't have. And it may be that you were both going at it, but that never justifies it becoming physical. And that's why some of these conditions of probation will hopefully be helpful. I also find that your plea is knowing and voluntary, meaning you've understood what we discussed and that no one has forced you to enter your plea. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, and all that means is that while you're on probation, if you have a minor violation, that'll be something that probation will work through with you. You don't have to come to court. But if it's more serious, in particular, anything involving you putting your hands on Ms. Jackson or anyone else in your family in a way that you shouldn't, that comes back to me. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Charles?
Yes, sir.
Mr. Jackson, is it okay if we electronically sign the indictment for you indicating your guilty plea?
Yes, sir.
You understand that today's plea resolves only the December incident you had with Ms. Jackson. You have an open, active case in state court in front of Judge Edie. That's the name of the judge. You've got a lawyer there, but you're going to need to keep going. Whatever the dates are for that case, you'll need to be showing up. This does not resolve that case.
Yes, sir. And I talked to my lawyer and she told me, she let me know.
Okay, good. Do you know if the child on the way is a boy or a girl?
It's a girl.
A girl, all right,
I begged for one.
okay. Mr. Jackson, I was inclined to sentence you to spend a little more time in. I do not want Ms. Jackson to have to navigate birth without you there. So what I'm going to do is sentence you on count 1 to 5 years to serve 3 months with the balance on probation. You've done 101 days, which is more than 3 months, so you'll get released. 5 years to serve 3 months, which means you have 4 years and 9 months of probation on count one. Counts 2 and 3 are both 3 months to serve. They will run concurrently with count 1. Special condition of probation number 1 is no violent contact with Ms. Jackson. She's referred to as Ms. Gilmore in the indictment, but we're talking about the same person. This is your wife, the mother of your child. No violent contact with her. Number 2, you're going to complete a family violence intervention program. Hopefully Ms. Rios has explained to you, that's not one class for 30 minutes. It's a bunch of classes over time. You don't take them all back to back. You're not going to college. But it's an investment, both financially and in terms of time. You will need to also complete the family first program. You'll submit to a drug and alcohol abuse evaluation, and that's just you meeting with a counselor to make sure that there's not alcohol or something else behind you getting out of hand with Ms. Jackson. Because if there is, then you're going to get treatment for that, which is good. That's meant to help so that you can be a stable presence in your new child's life. You are not helping your daughter if you're getting locked up every 6 months because you blow your stack and take a swing at Ms. Jackson. That locks you up, takes you away from your family, and your family is disrupted in that way. I'm going to waive your probation supervision fees for the first 6 months. 1, because you got to get back to work, and 2, you're going to be paying for the family violence intervention program. So we'll throttle back on the supervision fees. I think I covered everything. Any other conditions, Ms. Charles?
No, Your Honor, and just so he's aware, that within 48 hours, he'll be contacted by either through Ms. Rios or directly by one of our facilitators of the Family First program.
Okay. So someone will contact you about Families First. You're going to need to go report to probation, and Ms. Simpson's going to give you those reporting instructions in a minute. It sounds like you'll be living in Fulton County. That's where Ms. Jackson is. Okay, so you'll be reporting in Fulton County. I'm going to let Ms. Simpson give you those instructions, but know this, it's going to be.
So I have to write that case version then.
Okay, he hasn't bonded out on the misdemeanor case.
Oh,
So,
okay.
once you bond out, then you
Yeah.
report to probation.
Okay, so I want, yeah, so I plan on bonding out as soon as all the paperwork get faxed over, but I just ain't want any confusion going on with me still being in here and.
Got it. If you're locked up, you're not at fault for missing probation, but I'll let Ms. Simpson talk to you about that, and she may say it's 48 hours after your release, or she may say it's 4 days from today. They can decide whether they want to give you a specific time when you show up, or just this notion that, hey, we're going to know when you get out, whether it's today or Monday, and you've got 2 days after your release to show up. Do you know where probation's offices are? Okay, they're a couple blocks from here, but I'm going to let Ms. Simpson handle that. I'm glad you flagged it because you don't want to miss that reporting date, because that just means a warrant, and then here we are all over again. Okay, any questions about anything else?
No, sir.
All right, good luck with your new child, and good luck, Ms. Jackson, with everything. I hope this guy treats you well. So Ms. Simpson's going to come see you. Thank you, Ms. Charles. Yep. Ms. Rios, what would you like to do next?
Okay, so we'll do Edward Jones, and then I'll take a little bit break to talk to Ms. Pitts, and then we do her.
Okay, so we'll save Mr. Cook till the end. Okay, fine with me.
No, yes, who's that first? Oh, yeah. What do I do with it?
So we're ready for Mr. Jones, whenever you guys can get him out here. Bye. Another person from Michigan. So did he get pulled over for the seatbelt violation and then all this other stuff was in the car? Is that the basic storyline?
Pulled over for a ticket violation.
Okay. Pulled over for some reason and then lo and behold, he's swimming in fake IDs. Okay. Are you ready? Okay. Let's go on the record. This is position 2, State versus Edward Jones, 24 SC 002-627. Good morning, Mr. Jones.
Good morning, sir.
Mr. Jones is in court with his lawyer, Ms. Rios. We have Ms. Dilligard here to represent the state. Mr. Jones, I'm not going to list every offense in your indictment. It's a very long indictment, but Ms. Rios tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. In just a moment, Ms. Dilligard will put you under oath, ask you a whole bunch of questions. You should not be surprised by any of the questions because I know Ms. Rios has prepared you for this. But if at any point during our conversation you're confused about what's going on, will you let me know?
Yes, sir.
Okay. Ms. Dilligard?
Mr. Jones, can you please raise your right hand to the best of your ability? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct legal name for the record.
Edward Ronald Jones III.
Mr. Jones, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
32 years old and 2 years of college.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? You've been charged with 15 counts of identity fraud, 15 counts of forgery in the second degree, and 15 counts of possession of false identification with a government logo, and a seatbelt violation.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charges?
Yes.
Do you need any more time to discuss this case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Mr. Jones, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you the minimum and maximum sentence for each charge which you're pleading guilty to today? For identity fraud, the range is 1 year to 10 years. For forgery in the second degree, the range is 1 to 5 years. And for possession of false identification with government logo, the range is 1 to 5 years. And for the seatbelt violation, the range is 1 day to 12 months.
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to plead guilty to all charges for a sentence of 5 years probation and special condition that he complete 100 hours of community service. Is that your understanding of the recommendation? Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to render sentences consecutively?
Yes.
And do you understand that if the court orders to order a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
I'm on parole. I just made parole before I got brought over here
Okay.
Parole where?
in Kentucky.
And do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, to include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Jones, how do you plead to the charge, the 15 counts of identity fraud, 15 counts of forgery in the second degree, 15 counts of possession of false identification with government logo, and 1 seatbelt violation in indictment number 24 SC 002627?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years from today to file that petition, and for a misdemeanor charge, you have 12 months from today?
Yes.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on September 27th of 2022, officers performed a traffic stop on a white Dodge Challenger due to an illegal tint at 2489 Cheshire Bridge Road. While approaching the vehicle and speaking with the driver, they noticed an odor of marijuana coming from the vehicle. They also noticed that the passenger was not wearing his seatbelt properly. They asked both occupants, to step out of the vehicle to perform a search due to the odor of marijuana. While searching the vehicle, they opened up the glove box and found 15 ID cards stacked on top of each other. They were all Maryland or Connecticut ID cards. All the pictures of the IDs was that of Mr. Jones. However, they all had different identifying information, names, date of births.
Who was driving? Well, I mean, I don't really, if it wasn't Mr. Jones, was Mr. Jones driving or someone else was driving?
Someone else was driving.
So Mr. Jones was in the front seat, directly in front of the glove box, not wearing his seatbelt properly.
Correct.
Okay.
I'm not aware of any criminal history out of Georgia, but I did see at least 3 drug convictions out of Kentucky. One was in 2016, and I see 2 in 2024.
You said out of what state?
I think it's Kentucky.
Kentucky?
Yes.
Okay. Got it. Okay. Thank you. Mr. York, what do you have in terms of criminal history and Mr. Jones?
So I have 15 cycles with 4 felony convictions. The 3 Madam DA mentioned. Do you want specifics on those?
Just what was I know there was one recently, Mr. Jones, I think was out on bond in a case out of Kentucky when this happened. And then he went into custody in Kentucky and was recently paroled out. He'll clear that up when I get to him. But tell me what the most recent was.
Most recent that I'm showing was a possession of controlled substance, 1st degree methamphetamine, and that was March of 2024. The arresting agency is KSP Hazard.
Okay.
And I have 1 additional conviction. It's out of Michigan. This was in 2008, and it was for an armed robbery. I'm sorry, it's unarmed robbery is what it is.
Okay. That's one of the 4. So there's 3 Kentucky convictions and 1 from Michigan.
Correct.
Okay. Thank you, sir.
Yes, sir.
All right. Ms. Rios.
Yes, Your Honor. Mr. Jones is 32 years old. He will be living in Georgia if he's released. He wants to drive bulldozers, and he's already looked into the 2-week-long program that he will have to do to learn how to drive that equipment. He has 4 children, ages 13, 5, 2, and 15 months. He's never met the 15-month-old because he's been in prison, I believe, for long as the child has been born. He will be living with his little sister in Atlanta. I just ask you to accept the plea as negotiated. I don't believe anyone's identification was actually ever used from those cards that were in his possession, but he does admit responsibility and would like to get this case resolved and turn a new leaf when he gets released and take care of his children.
Okay.
I did also send you for an email from Mr. Campbell, who he worked with.
I read it from I think it's the Boys and Girls Club of Appalachia, the unit director. Okay. Mr. Jones, tell me why you'll be staying in Georgia rather than being in Kentucky or Michigan, or it's hard for me to tell where home is for you.
Yeah, I never lived in Kentucky. I caught the charges down there, and they are transferring my parole to Georgia.
Okay.
Yeah. And
when you say charges, I'm under the impression you have 3 cases there.
Yeah, one was in 2016.
Okay.
And the 2 most recent was in 2020. They indicted me in 2023 on the charges. I was released off a failure to indict when I caught the charges 2 months later.
Okay.
I wasn't on bond or nothing.
Okay. But what's your Kentucky? Were you living in Kentucky for a few years? I mean, there's a gap of time where you just dip into Kentucky, get arrested and convicted.
Yeah, I was down there with a cousin who lives in Hazard, Kentucky.
Okay.
For like a month.
But you have a 2017 case and then some from 2020. So those are 3 years apart.
Yeah, it was 2016.
Okay, 4 years apart. Were you living in Kentucky for 4 years?
No.
Where were you living then?
I was living in Michigan, and then I moved to Georgia in 2022, at the beginning of 2022 with my sister.
Right. So in the in-between time when you were living in Michigan, you would just periodically go to Kentucky and get in trouble? I'm not understanding how, for someone who doesn't live in Kentucky, you have been arrested and indicted multiple times.
Yeah, I was going down there with that cousin who I was mentioning, but yeah, I was doing wrong. I wasn't doing all right.
I'm not, I mean, yes, you were doing wrong. I'm just trying to understand how, like, you would take road trips from Michigan, but not with the purpose to go get in trouble in Kentucky. Were you guys bringing drugs down there, or
No.
how would you keep getting in trouble?
Just running with him. We both was doing drugs. I'd have been in rehab down there. Like that director, that was a rehab that I was in down
Oh,
there.
okay, that's from Kentucky. This,
Yes.
okay.
Yeah.
How, so did you do rehab in Kentucky?
Yes, in this prison incarceration for 9 months.
Okay. And when were you paroled out?
I got paroled April 15th, and then I went to extradition court for here, and you guys picked me up May 10th.
Okay. All right. When did you say your parole date was?
April 15th last month.
So if you didn't have these charges, April 15th, you would have been released from Kentucky.
Yes.
And where would you have gone when you were released?
I would have went to the halfway house that they recommended in Richmond, Kentucky, until my paperwork went through to be transferred to Georgia.
Okay. Because your goal was to get back here.
Yes.
And the place you have to stay is with your sister.
Yes.
Which is where?
In Atlanta, Georgia.
In Atlanta.
Yes.
Okay. And does your sister know you're going to show up on her doorstep in the next few days?
Yes.
Okay.
Yes, sir.
All right. And she's willing to let you stay there.
Yes, sir.
Your kids are, any kids here or all kids in Michigan,
All kids in Michigan.
including the 15-month-old?
Yes.
But you've been here since 2022.
Yes. They used to come down. His mom used to come down here.
Okay. And do all the children share the same mom?
The two girls, my first two, they have different mom. They got the same mom. Them two boys got the same mom.
Okay. Girls with one mom, boys with another mom. All right. And you provide support as you are able for them?
Yes.
Where in Michigan are your kids?
In Warren, Michigan.
Okay.
And two girls in Warren, Michigan, and two boys are in Detroit, Michigan.
Okay. Anything you want to add?
I just want to say that during this sentence, I changed a lot. I found myself. I know I've been a knucklehead. I grew up rough. I had a lot of childhood traumas, like a lot. But I'm tired of it. I want to get my life right. Like, I want to go back to school and finish out my college courses.
Yeah, you got halfway there.
Yeah, I got 2 years of college credit. I want to get back into a robotic program that I'm supposed to. And I want to take heavy equipment operators so I can drive bulldozers on the landfill that my little brother works at. He drives semi-trucks. He's been driving for about 7 years now. But he got stuff lined up for me to help me. I did a complete turnaround. My peer support who wrote you, he's going to help me get my peer support license. I'm going to help people, with their addiction, with their problem. Like, I was a good advocate where I was. Like, I was leading my group in a 12-step program, NA and AA.
Good. That's an important way to give back. Our peer support folks in our accountability courts are some of the most important components because you form that connection. Someone's able to say, no, I was where you, it's one thing for me to say, you need to be a good person, but someone who has struggled in the way that you struggled is much more able to connect with someone who's trying to climb up out of that. And there are plenty of opportunities for you to help down here. Your little brother who drives the semis, he's local also?
He's state to state over the road.
Okay.
But his company is out here and there in Michigan. I think they're in 2 other states as well. But
you understand that if you're on probation in Georgia, you pretty much need to stay in Georgia.
Yeah, I will be working on a landfill.
Okay. All right. And you feel like your addiction is under control right now, or would more treatment be something that I ought to require as opposed to you're going to go to support group meetings because you want to?
No, I have over 2 years clean. Yeah, I have over 2 years clean. I feel I have it under control.
How long were you in prison in Kentucky?
For almost 16 months.
So you have 2 years clean, 16 months of which in theory were forced on you as clean time.
Yes, I came through the door on the Suboxone. But when I came through the door, I turned that down. I didn't even want to take that no more. So I got 16 months just clear of Suboxone.
Right.
For the drug.
But you haven't been out confronting all the temptations of life. You feel like your recovery program is internalized enough that
I do, and I'm still being an active recovery. Like,
Yeah.
I'm still gonna be with my peer support group.
Okay.
Still on FaceTime calls, having group meetings
How often?
twice a week.
Okay. All right. I appreciate you sharing all that with me. We don't know each other real well, but it's helpful for me to get that little insight into how you've been working with your struggles. Mr. Jones, I find there's a factual basis for your plea. Pretty simple. You had these 15 IDs, and they sound like they were pretty impressive looking, but they weren't legal. But you didn't have guns and drugs, you had the IDs. I also find that your plea is knowing and voluntary. I am sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, which you will be for a while, if you have a small violation, I'm making this up, let's say you test positive for marijuana, you don't have to come back and see me. You and probation will work through that. But if it's more serious, you get arrested for anything, that comes back to me and we'll figure out what we're going to do. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Dilligard?
Yes, Judge.
And Mr. Jones, can we sign your name electronically on the indictment indicating your guilty plea?
Yes, sir.
Sounds like you have a place to stay, and Kentucky has already agreed to shift parole down here.
Yes, sir.
All right. Then I'm going to sentence you on all counts except number 46 to 5 years to serve 1 month with the balance probated. You will get credit from April 15th for that month of time because from April 15th onward, the only thing keeping you in custody have been these charges. So you'll be on probation for 4 years and 11 months. Count 46 will be 1 month to serve. It'll run concurrently with all the other counts. You will need to complete 100 hours of community service. You'll need to have knocked out the first 20 in the first 3 months. This isn't something we're going to have just lingering out there. I'm going to require that you complete at least 4 recovery meetings a month. Sounds like you're way ahead of that. You don't need to go someplace probation tells you to go as long as you're able to document the recovery meetings that you are attending. And I will set a behavioral incentive date of May 23, 2028. And all that means is if 3 years from today, you have taken care of your community service, stayed sober, and basically stayed out of trouble, we can end this case early because you will be driving those bulldozers, doing your landfill, taking care of your kids. If things are going well, let's get out of your way. If things aren't going well, you have another year and change of probation. Ms. Dilligard, anything else on behalf of the state?
Nothing further, Judge. Thank you.
Ms. Rios?
No, thank you.
Any questions, Mr. Jones?
No, sir.
Okay, your sister's house is in what county?
14.
Did you say it's East Point, or am I thinking of, where did you say it was? Where is it in Fulton?
It's on Park Lake Drive.
The street doesn't help, but is it Atlanta? Is it?
Yeah, Atlanta.
Okay.
Atlanta.
But you think it's Fulton, Atlanta, and not DeKalb, Atlanta?
Yes, it's Fulton.
Okay, all right. Ms. Simpson, who is with probation, she will not be your probation officer, but she is with probation, is going to give you reporting instructions. You ought to get out tomorrow at the latest. And when you get out, you're going to need to go report to probation so that you'll know who your officer is and what the expectations are going in.
Okay.
Any questions?
No, sir.
Okay, good luck with things.
Thank you.
Hope you meet your newest child sometime soon.
Can't wait.
I'm gonna go talk to Ms. Pitts and then I'll be ready on that last for you.
All right, so we'll take a brief break. I'll come back out in a few minutes unless Deputy Scott gets me because you're ready before I come back out. Do you have Ms. Pitts's case number?
Yes.
It's up there. Sorry to make you move around.
.5SC001178.
Okay, thank you.
Yeah, I can help you.
I'm just dropping these up for Judge McBurney. I just talked to Mr. Individual.
You want to come to the back or you want to wait?
He said he'd meet me on here.
Yeah, Joe.
I think it's his judicial assistant. Thank you.
Hey,
I'm Kayla.
hey, Kayla, you can come on up.
Okay, thank you.
These are all the certificates from yesterday.
That's correct. And then the orders of condition as well.
Oh, both, so I don't have to e-sign anything.
No,
Excellent, okay. Can you write down the phone number I should call when they're done?
Yeah.
There's a lot of new lawyers
I
for
know.
Georgia.
It was like what, 50, 60?
49,
That's crazy.
yeah, from all over the place. There was 2 from Greece, 1 from Israel, 1 from Brazil.
That's really cool.
Yeah,
For you. Well, thank you so
good
much.
for them, you bet.
It was actually, yeah.
Aha, okay. The DeKalb part of Atlanta.
Yeah, the apartment is actually close to him, I think.
Yeah.
Where? Westminster? I actually didn't get to watch him walk across the stage because my other son, the eighth grade class, those who wanted to, they went to New York for a big field trip. Manhattan, 2.5 days in Manhattan. And his flight was at noon on Sunday, and graduation started early at Westminster. It started outside, and in the middle of Justice Warren, who's on the Supreme Court here, she's a Westminster alum. She was giving the keynote address. There was lightning, and they had to send everyone into the gym. But that took like 30 minutes because there are all sorts of like grandparents who move slowly. And that 30 minutes was what we needed to have Calvin get across the stage. So we watched about 10 people's names called, but they start with a letter A and we're an M. And so Roscoe and I had to leave. So I have a film footage of him graduating, but Roscoe and I were on the road to Hartsfield. It was still a happy time, and we had a party at the house afterwards because I did not go to Manhattan. I just dumped Roscoe off at the airport. Said, "All right, good luck." And he's back. I picked him up 2 nights ago. It was a quick trip. It was Sunday through Tuesday. Yeah, so Tuesday night I picked him up. Yep. No, he'd been there with me. It was his first time with what he preferred in terms of supervision, it was like 6 teachers and 110 kids. So he was happy. So he's back. They have a few more days. His, I think they call it progression. He walks across some stage from 8. He's going to go to North Atlanta High School. And so all the 8th graders from his school go to North Atlanta, and they one by one walk across the stage, sort of symbolically leaving Sutton Middle School and going to North Atlanta. Yeah. That's next Wednesday. Yep. It's that time of year. There's not much happening in school.
When I was in elementary school, I was living in we didn't have middle school yet, and so after seventh grade, my eighth grade year was in high school.
Really?
Yeah,
Huh.
that was.
Yeah.
So, yeah, having to be thrown into high school life was.
Yeah.
But, yeah, luckily enough, my oldest god sister was there, she was a senior by the time.
So she protected you.
Sort of. Because there were some lunchtime, she was like, I have no clue who you are.
Acting like you're a stranger.
Or don't talk to me, don't even act like you know me, and so it way home.
Yeah. Well, Roscoe's excited. North Atlanta is a big school. It's in that old IBM building. It's a funky location. But for an APS high school, it's pretty nice. And he's ready to explore that. We'll see what happens.
I graduated with my mom's high school. Right of the year, a year or two after we graduated, they decided to renovate the school and redo it. Place was
Totally different.
we
Yeah. Yeah, this building,
were mad. 'Cause
you missed out.
Look got all these new extended parts, these extended buildings now.
Yeah.
So they were able to add on additional, let the
You had none of that.
places after. Or,
Yeah.
oh my, I did this before we left.
Yeah, North Atlanta, it's an 11-story building. So they tend to have the upperclassmen higher up, but like your senior year, your junior year, you're on the 10th and 11th floor of a big old building. That's going to be very different from what he's been doing. For school? So we weren't sure he's going to play baseball there if he had to go early for a sports thing, but baseball being a spring sport and it being a school that's more academic focused than athletically focused. Like, no, you show up when all the freshmen show up. So sometime in September, I think it's on the calendar. They have whatever day freshmen are supposed to show up. It's not just one day. It's like move in. There are a few days that you move in because we got to fly up there. You don't have to, but we're flying.
Excited.
He is. He's excited because he's got a summer. He's playing in a college baseball league all summer, and his friends are now just goofing around. And then he's going off to college. Life is good. What's not to like? I don't see him awake much because he's asleep when I leave for work, and he's out when I come home from work. He gets home after I'm asleep. I think he's still living with me. We're going to the Braves game on Saturday, so I will see him then, at least. Yeah, I had to lure him with Braves tickets. Could I see you if I bring you to the Braves game? All right. Ms. Rios, are we ready?
Yes,
Should we bring Mr. Cook out, or should we take care of Ms. Pitts?
let's let Ms. Pitts go.
Ms. Pitts, come on up, please. Stilligard, are you ready?
Yes.
All right. This is not on the calendar. 25 SC 001178, State versus Pitts. Ms. Pitts is here with Ms. Rios, and Ms. Dilligard is here for the state. And Ms. Pitts, you've now sat through a plea, so you know how it's going to work. Obviously, your case is different charges, different facts, et cetera. But Ms. Dilligard will put you under oath, ask you a bunch of questions. I need you to let me know if you ever have any questions, okay?
Yes.
All right, Ms. Dilligard.
Ms. Pitts, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do. Yes, ma'am.
You can lower your hand. You can lower your hand.
Oh, okay.
Please state your true and correct legal name for the record.
Lashana Pitts.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you've not taken today?
Supposed to be on mental health medication. Yes, ma'am.
You say you're supposed to be. When you're taking it, what is it for?
Schizophrenia, depression.
Okay. When did you last take medicine to help you treat schizophrenia and depression?
Way when I was incarcerated.
How long ago was that?
That was almost 2 years ago.
So you have not had your medication
I've been out.
since you've been out.
No, sir.
How come?
Well, really, I've been, since the charge, I was trying to stay out of the household. So I really was in Washington, Georgia, with my mom. You know, that's a small town.
I know where Washington, Georgia
Yes,
is.
yes.
Okay, so you were staying away like you're supposed to,
Yes, sir.
but that kept you away from
I
your,
don't have Medicaid insurance.
okay,
You know, the charge, was keeping me from getting a job.
okay. So, the fact that you have not been taking your medication, do you think that is interfering with your ability to understand what we're talking about?
No, sir.
No? Okay. All right, Ms. Dilligard.
Ms. Pitts, how old are you and how far have you gone in school?
I'm 41 and, the highest grade I completed was 10th.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? It's 1 count of aggravated assault with the family violence designation, possession of a knife during the commission of a crime, and 1 count of terroristic threats.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
And do you understand that if you plead not guilty or remain silent or refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in this indictment to include the facts and circumstances related to the charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Ms. Pitts, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you the minimum and maximum sentence for each charge which you're pleading guilty to today? Judge, we are reducing count 1 to battery family violence. We're submitting a no pros to the court for count 2, and we're reducing count 3 to reckless conduct.
All right, so all misdemeanors.
Yes, Judge. The range for those charges is 1 day to 12 months. Do you understand that?
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state's recommended sentence is, again, to reduce count 1 to battery family violence pursuant to OCGA 16.5.23 subsection F. And a no pros on count 2, and to reduce count 3 to reckless conduct pursuant to OCGA 16.560 for a total sentence of 24 months probation. We did discuss that if it does complete the conditions that I mentioned, that after 12 months it can be suspended. The conditions are 40 hours of community service to complete FVIP. And Judge, there's one, we didn't discuss this, but after hearing Ms. Pitts earlier in the colloquy, I would ask to do a mental health evaluation and any treatment that is prescribed.
Okay.
Is that your understanding of the recommendation?
Yes, ma'am. Yes, ma'am.
Do you understand that the court's not required to accept the state's recommended sentence?
Yes, ma'am.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that there are multiple charges to which you're pleading guilty to today. The court has the right to run those sentences consecutively.
Yes, ma'am.
And do you understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw that plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
Mm,
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow the special conditions of your probation?
Yes, ma'am.
And do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses to include any mental health defenses?
Yes, ma'am.
And do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Okay, Ms. Pitts, how do you plead to the reduced charge of battery, family violence, and reckless conduct in indictment number 25 SC 001178?
You said, how do I plead? Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on June 5th of 2023, officers were dispatched to 339 Larchmont Drive on a dispute with a weapon. Officers, the remarks to officers were from the defendant's 16-year-old daughter who called 911 because her mom was coming at her with a knife. Upon arrival, officers spoke with the defendant who was outside the home, unarmed and on the phone. Ms. Pitts stated that she was in an argument with her daughter because her daughter was disrespecting her. Officers then spoke with the three daughters that were inside of the residence. The oldest daughter, Miss Sakythia Pitts, that's Sakythia, stated that she heard her mother and her sister arguing and then heard her mother state that she was going to stab her sister and then went to the kitchen and retrieved a knife. The sisters then ran into the bedroom and closed the door. The defendant then came into the door. The victim was able to utilize a chair to keep her mother away. The defendant then left the room, and that's when the daughters called 911. I did speak with the victim in this case. I spoke with her previously to get permission about the graduation, and at that time spoke with her of how she wanted to see the case resolved. She didn't want to see her mom spend any time in custody. She just wanted her to get the help that she needed.
Okay.
So she was comfortable with the resolution. I did try to contact her some this morning, but wasn't able to reach her for her to be present.
Okay. Thank you. Mr. York, do you have any criminal history information about Ms. Pitts? She wasn't on your calendar, so if you haven't had a chance to look it up, I understand.
Correct. I do not have anything for her.
Okay, meaning you didn't get to look it up, or the system
Correct.
shows?
I mean, I did not get a chance to look it up.
Got it. Okay, thank you. Ms. Simpson, did you have a chance to look anything up? Not in your system. Okay.
Judge, I only see, I see this as her first arrest cycle out of Georgia.
Okay.
I don't see any other criminal history for her.
Got it. Ms. Rios.
Yes, Your Honor. Ms. Pitts is 41 years old. She has 5 children. Oldest is 23, the youngest is 17. She last was working at Dollar General, but this case was affecting her employment, so she hasn't worked since, and she's been living with her mom. She wants to put this case behind her so she can start looking for employment again and be able to get on Medicaid and address her health needs. So I just ask that you accept the plea as negotiated.
Okay. Ms. Pitts, anything you want to add?
Yes, sir.
Your daughter who just graduated, the one who was the victim in this situation, what's she going to go do?
She said work. She want to do cosmetologist.
Okay. And was that your youngest child, or is there someone younger than that?
I have one up under her. Yes, sir.
Okay. And she's still in high school?
She
Or
on
he?
her last year.
Okay. A senior, meaning
Next year.
one more year?
Yes.
Okay. Ms. Dilligard, what is your understanding, and maybe Ms. Rios can answer this, when Ms. Pitts had to leave the household, in other words, the condition of bond was you can't be around, who was the parental figure in the household for the victim here?
Your Honor, nobody.
Okay. How do you pronounce your daughter's first name?
So Keithia moved on and got her own place. That's who they was saying originally that they was there with, but she eventually got her own place. So they're just there unsupervised. And
Okay. How do you pronounce your daughter's name who just graduated?
Rakia.
Rakia.
Yes.
So Rakia lived with some older sisters?
No, they all was in my household.
But you moved out. You moved to
I
Washington.
left. Yes, sir.
So who was left in the house?
At first it was Keithia. She got her place in August of last year.
Okay. And she's the one who's 23 now?
Yes, she's now 20.
Okay. So there were adults in the household, but there wasn't a father figure or an aunt or something like that? No? Who was paying rent?
They on Section A.
Okay.
Yes, sir.
Got it. Okay. Well, Ms. Pitts, I find there is a factual basis for your plea, that your plea was knowing and voluntary, meaning you've understood what we talked about. Any questions about anything?
No, sir.
Okay. And voluntary just means no one's making you enter this plea. You've decided this is how you want to move forward. Do you agree with that?
Yes, sir. Yes, sir.
Ms. Rios, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Dilligard?
Yes, Judge.
And Ms. Pitts, is it okay if we sign your name?
Yes, sir.
Great. Ms. Pitts, I will sentence you on count 1, which has been reduced to family violence battery, to 12 months to serve 2 months with the balance probated, although you've already served over 60 days, so you're not going back into custody. You'll have 10 months of probation left on that. And then count 3, because count 2 is dismissed, count 3, it'll be 12 months probation to run consecutive. So it's a total sentence of 24 months, serve 2 of those, and then 22 months on probation. Special condition of probation number 1 is that you submit to a mental health evaluation and you follow any treatment that is recommended. I suspect it'll be, let's get you back on medication for schizophrenia and depression. Special condition number 2 is that you complete a family violence intervention program, which is a series of classes that'll help you work through family relationships in a way other than you did 2 years ago in June. Number 3, you will need to complete 40 hours of community service. And then number 4, and this is really part of the treatment, but if you are prescribed any medication, you need to stay on that medication as long as you are on probation. Okay. I'm going to waive your probation supervision fees for the first 6 months while you get back on your feet, get a job, whatever's going on. And hopefully during those first few months, you can knock out as much of the family violence intervention program as possible. And if after 12 months of probation, you've taken care of business and completed your conditions and are compliant with any treatment or medication, then the probation team can decide to terminate you early. But if you still need some supervision because you just started your medication or you're still trying to finish family violence intervention, then we won't terminate early. It's not a penalty, it just means we don't end early.
Yes, sir.
Any questions about that?
No, sir.
Ms. Rios, anything else?
No, Your Honor.
Ms. Dilligard?
Nothing further, Judge.
Ms. Pitts, you will either hear from Ms. Rios or someone will reach out to you directly from misdemeanor probation about reporting instructions.
Yes, sir.
They're based very near here. Usually reporting is virtual, meaning you can call in, but you may need to show up in person once just to register.
Yes, sir.
Now that you've resolved your case, do you intend to move back to the Atlanta area? And if so, where?
I'm really actually physically at my daughter's house right now, helping her with my grandson, which
Which
I gotta
daughter,
go through
Kia?
all this, Sakithia.
Okay,
Yeah, she has an autistic son.
okay. So you're staying with her, helping care for her son?
Yes.
All right, well, you're welcome to keep staying there. I was asking only because if you're now back in the Atlanta area, again, it's just gonna be a lot easier to deal with probation.
Right, that's why I stay here, yes, sir.
Okay, all right. Well, if you don't have any other questions, we're done.
Okay, thank you.
Good luck.
Thank you.
Can we bring out Mr. Cook, please?
Hello, I was wondering why I didn't get called out. I was got the word.
Oh, no, we just had to do other stuff, but we're doing it.
Did you call Pad?
Yes, we did the referral to Pad.
And
You
what
said
did they say?
that you just have to stop in. You just can go there. When you get released, you just go to Pad.
And they'll let me in?
Yeah.
I'm
You know where
I'm
they're all-
sorry. Good morning. Pat, I know we haven't started on Mr. Cook yet, but Pat did say they would have somebody come out to see him by Friday or no later than early next week.
Okay, well, great. Well, we'll close the loop on that in just a second. Let's get on the record in Mr. Cook's case. His Fulton case is 23 SC 1900975. Mr. Cook is here in court with his lawyer, Ms. Rios. We've got Ms. Dilligard as a prosecutor. We have Officer Brown from DCS and Ms. Simpson from DCS. Mr. Cook, we are talking about you and probation and how to get you the assistance you may need. In your case, let me pull it up here. We have two cases. You have a Gwinnett case. Your probation in your Gwinnett case expires in about 48 hours.
Really?
Come Saturday, you are not on probation out of the Gwinnett case anymore.
That's surprising.
Okay, well, there's your surprise. But that is, you'll remain on probation in this case. And I'm just looking up your final disposition. You had 6 years of probation. You've got 3.5 left. So there's still plenty of probation. It's just now one case. And we're going to talk today about modifying your probation so that you can be in Fulton County, because that's where you found a care network. And it's a little perverse to be arresting you for trying to get help because where you found help is in Fulton County. So that's the main conversation. How have you been doing on probation,
I've been doing good.
other than coming into Fulton County?
It's a long story.
It's okay. You don't need to tell it. If that's where you found help, the good news is that Officer Brown is saying, Judge, can't we fix this, the probation condition, because she wants you to connect with help. It sounds like PAD is ready to provide additional support, but that support might continue to be here in Fulton County, in which case modifying your probation makes some sense.
I don't know anything about those people. I've
Okay,
never really had any help in the sense of rehab or getting issues and getting around right people in one sense and in one direction. I kind of got sent to prison many times.
you have been sent to prison a lot of times, but you found, is it a church here where they're getting you some help?
Yes, sir.
Okay.
But they only do so much.
Okay, well, PAD can help with more, and they're gonna come meet with you. So I don't mean to say we are imposing on you an unknown situation. And I'll also add that PAD is purely voluntary. I'm not actually gonna make PAD, which stands for Policing Alternative, a D word. But it's diversion out of being in jail and arrested. It's purely voluntary. If you don't like how PAD feels, you can say, I'm not going to do this. We cannot make it, and I would not make it a condition of your probation. But I wanted you to know, and Officer Brown wanted you to know that that was coming. Officer Brown, were there other concerns you had about Mr. Cook? I'm going to pull up his warrant again that I signed just to see if there was anything else.
No, Your Honor, that was the only issue.
Okay. Did you go to RSAT?
No, sir. I was on a waiting list. And it never happened. And there was I was under the impression that I had a 5-year sentence and that I had to wait to get on the list to go to that. Well, the next thing I know, there was no help for any counselors, and they came to me out of nowhere and said, "You're getting out." So they kind of threw me out on the street with nowhere to go.
Okay. Were you sentenced to RSAT in the Gwinnett case?
No.
Okay, because I'm looking at your Fulton case.
Thing had ran out, I guess because I maxed out.
Okay. The only condition in your Fulton case, bless you, in connection to RSAT was to complete the aftercare program. So not RSAT itself, but the aftercare. Maybe Officer Brown, can you shed some light? I'm confused. It's my sentence. I signed it. Why all it was RSAT aftercare in the Fulton case and not go do RSAT?
Unfortunately, Your Honor, I have no idea.
Okay.
Issue with that anymore.
Pardon me?
I do not have a drug issue anymore. That is not my identity.
What is your identity now?
In Christ.
Okay. So you think you've kicked the habit, whatever your habit was. What were the drugs that you abused most frequently?
Crack.
Okay. When did you last use?
It's been a long time.
A long time can be an hour. A long time can be 4 years.
Since when I had to face you and got into all that trouble.
Okay. You were sentenced in March of 24, so a year and a couple months ago. You're saying you haven't used since then?
No, I ain't been out long.
Well, it's not a big challenge to not use if you haven't been out long. How long have you been out?
I don't know, 5 months.
Okay. But those have been 5 months of clean time for you?
I've been doing good.
Good. We want you to continue to do well, Mr. Cook, which is why, unless you object to it, I'm going to modify your probation by removing the condition that you stay out of Fulton County. I do find, this is a revocation hearing, I do find that you violated the terms of your probation because you were in Fulton County, but I don't find that you did that in a malicious way. You weren't breaking into places again. You were trying to get help at the church. So I will check one thing and then tell you what I'm going to do.
Can we also remove the complete RSAT aftercare?
Yes, that mystery condition. Yes, ma'am. And you were saying, Officer Brown, that the good folks from PAD are coming to visit Mr. Cook at Rice Street?
Yes,
And you were saying that was going to be tomorrow or next week?
tomorrow.
Okay.
And they said if not tomorrow, first thing next week.
Okay. Hold on, I will hear from you. Assuming Pat and Mr. Cook have a good connection, how do I learn that so that I can do a release order so that Mr. Cook is released to Pat? I don't want him to get stuck. And
The representative from PAD stated that she would contact his attorney and myself
great.
to let us know the outcome.
Got it. So one of the two of you will know about this. And once you let me know that, then Ms. Rios, you should be able to do whether it's a transport order or a release order, and I'll just make sure the revocation order matches that. So Mr. Cook, here's the game plan. I am revoking your probation because you came back to Fulton, but I'm going to revoke it to only however long it takes, Friday or Monday, for Pad to meet with you. It may be Tuesday because Monday's a holiday. For Pad to meet with you and for Pad to decide, can we help Mr. Cook? And for Mr. Cook to decide, I would like to take you up on your offer. I would like to try out. And it's not going to be a condition of your probation. Again, Pad may say, hey, join us for this. We'll give you help with that. I don't know why you'd say no, but if you choose to say no, that's between you and Pad. They will not accept their treatment to be made a part of probation because it's always the participant who can walk away if he wants to. Does that seem fair?
Yes, sir.
Okay.
You've answered part of the question, so am I right to say that when these people come out to see me at some point next week, that they have a bed for me and have housing?
I don't know the answer to that, but they will be able to talk to you about that. And they may say, in fact, we've got a bed now. They may say the bed will be ready in 1 week. I don't know how that plays out. PAD itself isn't a place with housing, but they connect you with housing resources.
Oh, okay.
And so they may say, we found a house for you, a bed for you in place X. And if you choose to go there, you can go there. That won't be part of your probation. It will be an opportunity for you to be serious about being the changed person you said that you are. But I need you and Pad to have that conversation. And then Pad reaches out to Ms. Rios as well as Officer Brown. They'll say, here's the deal. Mr. Cook seems interested. We're interested in helping him. And the bed's available on day X, and we'll come pick him up. I'm going to sign an order that tells the sheriff's team, please release Mr. Cook on date X to Pad, or transport him to, as long as it's nearby, to this place.
I have no way to get there.
Understood. Sometimes Pad comes to get you, and there's your transport. If not, then I ask the sheriff nicely to deliver you to wherever that place is. But that's all voluntary. The parts that's not voluntary is that you remain under probation supervision. And so you'll need to stay in touch with Officer Brown. If that means you got to get yourself to their office, you do that. If it means get yourself to a payphone, I don't think those exist anymore. So you borrow someone's cell phone, whatever it is. But you can't be a stranger to probation. Got it?
Yes, sir.
Questions?
Yeah, my number, right?
I have nothing.
I gave you my number last
No,
time.
you
Okay,
didn't.
let me write it down. So you call me if you meet with Pat, just so the radar. You
How
give
do
me
you send your first name?
Ania. I haven't write my name yet. Right. If I don't answer, just keep calling. I'll eventually answer. My calls are transferred to myself.
Officer Brown, are there more things that you think Mr. Cook should hear while we are all together so there's no confusion or misunderstanding?
No, if Miss Simpson can give him my information, so he can call me as well once all is said and done, and once he's released, so I can give him further reporting instructions. Because I will not be his officer once he's released. He will be transferred to our field office, because I'm in courts.
Got it.
So he would have another officer.
But you'll help him with that transition, letting him know who that is
Yeah.
and how to reach that person.
Yes, Your Honor.
Excellent. So a couple things, Mr. Cook. One thing that does not change, Ms. Rios is your lawyer. And so if you are not able to connect with probation, you can reach out to her. She'll help make the connection. But until Officer Brown, and you see her on the screen right there, until she says, here's your new officer, because you will have one who's out in the field and who can meet with you, it's Officer Brown. So you're going to get her contact information, and that's who you need to reach out to when you are settled. When you figure out, hey, I'm in this shelter, I'm in this rooming house, whatever it is, you're going to let Officer Brown know, and then she can give you instructions about either how to call your probation officer, whoever that's going to be, or how to report to the probation building, which is a couple blocks from here.
Can I get that number today?
You're going to get it today. Ms. Simpson, who is a colleague of Officer Brown, is going to leave. So you're going to leave with two numbers. You should lose neither of them, Ms. Rios's number and Officer Brown's number. And you're going to meet with your hopefully new friends from PAD either tomorrow or early next week. And if that goes smoothly and they say we're all set, then I will sign your release order.
I appreciate y'all.
Okay? You take care of yourself.
Thank you, Judge McBurney. I didn't know what to do with this case.
I appreciate the way you were proactive about this. The last thing we needed to do was say, get out of Fulton when Fulton was helping them out. So Ms. Simpson will prepare the revocation order that will also modify probation, striking those two conditions, obviously reinstating him on probation, and we'll see what happens with Pat. I suspect we'll be together again soon, but that it will be in a different setting.
Okay, thank you, because I just didn't want him getting arrested again for trying to get help.
Yep. No, I very much appreciate your approach to this, and sorry you had to sit around this long, but we've now taken care of all our cases.
No problem. You all have a safe holiday weekend and take care.
All right. Bye-bye. All right. I think we've knocked everything out. Anything else, Ms. Rios, from your set of cases? Nice work getting people in here to resolve things on this bonus morning. Ms. Dilligard?
You're welcome.